What's everything that you need to know in order to win your VAWA case in 2026? My name is Moumita Rahman, and for the past 15 years, I have been working as an immigration attorney, helping thousands of immigrants successfully file for VAWA across the United States. This means that I know quite a lot about what USCIS is looking for in your case and how to help get it approved and how to avoid common pitfalls. And that is especially important with the Trump administration in power right now. So I'm going to share the top few things that you can do to win your VAWA case, including the number one piece of evidence that can help you get approved. And make sure that you stay tuned until the end, because I'm going to explain what to expect at your VAWA interview and what you should know if you are worried about ICE. The first thing that we need to talk about in order for you to have a successful case is timing. I have seen strong VAWA cases get denied because of timing issues, and the timing issues may show up in ways that you don't even expect. The first instance where timing becomes an issue is if you are divorced from your spouse. The main problem is someone is in an abusive relationship, they leave, they get divorced, but then they wait way too long to file for VAWA. And whatever the reason for the delay might be, it does not matter to USCIS because this is a hard and fast rule, and all they are looking for is the date that your divorce was entered and became final with the courts. This means that they are going to look to see when did the judge actually sign the divorce decree and when did it get finalized and entered in court. So it doesn't matter when you find out about your divorce if you didn't even know about it. It also does not matter when you start your divorce. What matters is when it becomes legally final. And this is important because once your divorce becomes legally final, you only have a period of 2 years to make sure that you get your VAWA done, prepared, and filed. If you end up filing your case even one day after this 2-year period passes, USCIS will deny your case because, as mentioned, this is a hard and fast rule. I need to mention at this point that you do not, in fact, need to be divorced in order to file for VAWA. In fact, you do not even need to be legally separated or separated from your spouse in order to have a successful VAWA case. We have had many cases approved even where client is still living with their spouse. USCIS is required to keep your case confidential so that your safety is never compromised. So don't let anyone convince you that you have to get divorced in order to file your case, because as we know, divorce is complicated, it takes time, it takes money, but VAWA is here to help protect your immigration rights, even despite having to go through the family courts to get a divorce. Now, here is another timing issue that is surprising, but also comes up. If you have filed for VAWA and you have gotten divorced and you get remarried at the wrong time to a different person, it may totally invalidate your VAWA case. If you did not already know, once you file your I-360 application requesting approval underneath the category of abused spouse of a U.S. citizen or green card holder, you must wait to get married a second time after the I-360 is approved. If this timing is all wrong and you get married even a day before your VAWA is approved, then it will cause your case to become null and void. And this applies only to your I-360 application. It does not matter if your I-485 is approved or not, because the only thing that we are looking at here is your I-360. So make sure that if you end up finding somebody again after your relationship ends with your abusive spouse, make sure you don't end up harming your immigration status by getting married too soon. So now that brings me to my next point, proof. What kind of proof will you need in this year to win your VAWA case? Well, as you may already know, USCIS did publish an update to the USCIS VAWA policy manual. And I have taken a very, very close look through this entire policy manual, comparing it word for word against the old policy manual. And here is what I have found. The standard of evidence to judge your VAWA case has not changed. And this is very, very important to understand. The standard of evidence required to prove and win your VAWA case is any credible evidence, and your burden of proof is to prove that you suffered either extreme cruelty or battery and that you are in a good faith marriage by a preponderance of the evidence. What this means is that you must show that it is more likely than not that you did have a good faith marriage and that during the course of this marriage, you did suffer either extreme cruelty or battery. So this is something that has not changed between the old policy manual and the new policy manual. Rather, what the new policy manual does is give more examples and stretch out the language a lot more to explain what they consider to be evidence of this. And I want to remind everyone again that Congress specifically created the any credible evidence standard because precisely of the fact that it knows that survivors of violent or abusive relationships often have very little access to documentation and have very little proof of what has happened. So if you don't have a lot of evidence to show for your case, don't worry. There's still a way to get your case approved, which I'll explain in a moment. But first, let's go over the type of proof that USCIS wants to see. The first category of proof that you must show has to do with the eligibility category of showing proof that you are married to a U.S. citizen or to a lawful permanent resident. This causes a lot of panic because in a lot of abusive relationships, your spouse may simply refuse to give you a copy of their passport or their green card. And this is going to be considered primary proof of their status as a citizen or resident. But even if you do not have this, it should not stop you from filing for a VAWA because as the policy manual lays out, even with this new update, you can still satisfy this proof with other secondary evidence, such as through proof of a request to verify your spouse's status by supplying little pieces of information such as their social security number, their date of birth, the city or state where you believe they were born, and any other information that you can find. I would recommend trying to look up voter registration records as well as anything that you can find online that may help prove their status. If your spouse ever previously filed an I-130 for you or for your children, that receipt by itself can also serve as proof because USCIS can easily locate the file and the information to verify that your spouse is either a green card holder or a U.S. citizen. Also, something that we have done commonly in our office is looking to see what your marriage certificate says about the place of birth of your spouse because frequently it will list a U.S. location, which you can ask USCIS to cross-reference to verify their status. The next category of proof that USCIS will look for is proof that you are in what is called a qualifying relationship. So what does qualifying relationship mean? I want to point out that qualifying relationship is actually different than being in a good faith marriage. So let's go over each of these two differently. A qualifying marriage simply means that you are in a legally valid marriage to your U.S. citizen or to your green card holding spouse, and that you are also free and clear to marry them. So first, you must provide an official marriage certificate to show that you are married, and this certificate must be valid in the state or country where the ceremony was performed. Next, you yourself must show that you were free and clear to marry. And this is important for those of you where this is not your first marriage. It is incumbent upon you to show that all of your previous marriages ended in legally valid and binding divorces. This is where I see a lot of people's cases get denied because they may have been married before and they thought they were divorced, only to find out later through a USCIS denial or through a USCIS request for evidence that in fact, the documentation they have is either fraudulent or not actually considered legally valid in their home country. Also, please note that in many places, there may be a waiting period that you have to go through in order to have your divorce be considered final. This may mean that where a judge has granted divorce, you may have to wait for a period of a few months before the divorce is considered finalized. You must make sure to not remarry prior to this validity period ending, otherwise your current marriage will be considered to be invalid. Now, let's let's talk about good faith marriage. Good faith marriage means that you must show evidence that you entered into your marriage for the purpose of having a life together. For this, USCIS is looking for evidence of how you commingled your life and about your intentions at the onset of the marriage. They will look for evidence to understand how you met, how you built your life together, and how the relationship developed. Evidence to show such things include primary evidence as well as secondary evidence. Through the new policy manual update, USCIS does make clear that they want to see more primary evidence, but again, I remind you that the standard of evidence is still any credible evidence for VAWA applications. So primary evidence is going to include the traditional sorts of documentation such as joint leases, joint tax returns, joint bank account statements, insurance policies, certificates of children born through the marriage and during the marriage. And secondary evidence will include such things as photographs together, text messages between each other, proof of travel together, and witness statements. There is no one single piece of document that can prove a good faith marriage. Rather, USCIS is going to look at everything in the totality of the circumstances, including by what you say through your affidavit. And in the new policy manual, USCIS clarifies that the length of a marriage does not automatically determine whether or not a marriage is considered to be good faith. Therefore, even if the marriage is no longer viable or it only lasted for a short period of time, it can still be considered to be good faith. However, they emphasize they will still look at everything in the totality of the circumstances, which means, in my opinion, that the shorter your marriage, the quicker your marriage, the harder you must work to prove that everything was legitimate and valid. This includes your details through your affidavit as well as through documentation. Next, another category of evidence that you must provide is proof of shared residence. This is one of the most commonly misunderstood parts of a VAWA case, and there is a new update that you must be aware of from the new policy manual updates. Proof of shared residence means proof that you and your spouse lived together exclusively in the same place. And what this means is that neither of you could have maintained any other separate residences during this time period. And here is where things have changed in the new policy manual. Before this, we could show that shared residency could occur before you get married or even after your marriage has ended. But now USCIS is making clear that your shared residency must occur during the time that you were legally married to your spouse. So now let's talk about proof. Again, there are going to be primary evidences that you can show as well as secondary evidences. Primary evidence of shared residence will include things such as joint leases, joint mortgage statements, and of course, joint rent receipts. Secondary evidence would include things such as mail sent to both of you at the same place, joint tax returns, children's or doctor's records, and other employment records showing the same address. But of course, in abusive relationships, it is actually very common to not have both parties' names on the same documents. And if this is your situation, you'll have two options. You can show separate documents sent to you both around the same time to the same location. And of course, you can get witness statements from neighbors, landlords, or others who can testify that they have seen you live together. The next requirement is that you must show that you suffered extreme cruelty and battery during your relationship. And this is another part that causes a great deal of confusion. USCIS requires you to prove either one of these two types of abuse. You are not required to show both. Battery is going to be your physical violence, and extreme cruelty is more about the emotional abuse. Extreme cruelty includes things such as threats, intimidation, coercive control, emotional or psychological abuse, financial control, isolation, and immigration-related abuse such as threatening deportation or arrest. The law is very clear on this point. Abuse does not have to be physical in order to qualify. Congress specifically created the extreme cruelty category in order to help people who are stuck in abusive relationships, and so as not to require people to have to suffer to escalations of physical violence in order to qualify for immigration relief. And a lot of people think they need police reports, but this is simply not the case. Police reports, restraining orders, and violations of protective orders can help, but they are not required. I have filed many successful VAWA cases that have been approved without any of these things at all. Both USCIS and Congress understand that many survivors never call the police because of fear of threats of deportation. And other types of evidence that may assist are medical records, therapy or counseling records, text messages, messages that show abusive language, verbal abuse, and emotional blackmail, as well as other types of voicemails or emails, photographs of injuries or property that are damaged and broken by your abusive spouse, shelter or social service records, and also witness statements from people who have personally observed your suffering of the abuse. All of these things are considered to be acceptable underneath VAWA's any credible evidence standard. And in fact, this is not an exclusive list. There are other things that you may be able to show as well. Another requirement in a VAWA case is showing proof of good moral character. This part scares people a lot, especially if they have previous encounters with law enforcement. People may often think that they have no options because of a prior record, but this is not always the case for a VAWA application. You may still be able to get your application approved for VAWA even if you have a prior record. However, you do need to be careful and have your convictions analyzed to make sure you meet the definition of good moral character. When USCIS looks to see whether you have good moral character, they primarily look at a few things. They look to see the time when you have your conviction, to see how close in time it is to your VAWA application or how far back it is. And yes, no matter how long ago your conviction occurred, it may still affect your case. Typically, convictions really only matter when they occur within the past 3 years before you file your VAWA application, but this can be an ongoing look back period. And especially underneath the current administration, they will be looking at criminal convictions more closely. USCIS will want to see police clearances from every place that you have lived for at least 6 months during the past 3 years before you file, or something that is equivalent, such as an FBI background check. And of course, if you have actual encounters with law enforcement for criminal charges, even if they were dismissed, you must provide dispositions showing the final outcome of every single charge, even if they resulted in a dismissal or expungement. Your written affidavit also matters here. In your affidavit, which is a sworn statement, you can explain why you are a person of good moral character, your role as a parent, your responsibilities, and of course, if you have had any convictions in the past, how you are regretful of those actions and how you are rehabilitated from those times. In addition, you can provide letters of support from people who know you as a good citizen in the community. These can come from family members, religious members, local politicians, even employers who can vouch for your character. So now let's talk about how much evidence do you actually need? This is one question that frequently gets asked at my office by clients, and people want to know exactly how much do I need to show to prove my case. The honest answer is number one, we don't know because every case is different and it's subjective. But number two, you probably have more evidence than you realize. I have had many cases approved with very little beyond my client's written statement. But winning your case this way only works if your affidavit is written the right way. So right now we're going to talk about the most important piece of evidence that you can have in your case, which is your affidavit. After working more than 15 years as an immigration attorney filing VAWA cases, here is what I can tell you. Two people can go through the exact same abuse. They can file the very same paperwork. They can even submit the very same evidence, but only one may get their application approved because only one submitted a well-detailed affidavit written in a way that explains how the abuse occurred, why it occurred, and how it affected them. And now, according to the new policy manual updates, it is even more imperative to describe what happened the right way. A lot of VAWA applicants will simply just write statements about what happened. He yelled at me. She insulted me. We argued all the time. But describing what happened to you in this limited manner is not going to help you win your case. In fact, USCIS clarifies in its new policy manual update that hurtful conduct alone is insufficient to establish that a person suffered abuse. Instead, what you now have to make sure you are very clear on describing is why your partner put you through that sort of abuse, what they hoped to gain by using that sort of abusive action against you, and how in turn it made you behave, how it impacted your daily life. And this comes down to really one thing, showing a credible pattern of power and control. This means that you must be able to establish to USCIS that throughout the course of your marriage, your spouse used a series of actions designed to exert their power and control over you. So you must explain to USCIS how your spouse may have used fear, pressure, threats, control, or even violence to dominate and control your life. Let me give you some examples of what this may actually look like. Instead of saying, my spouse yelled at me and put me down, you will want to explain when the yelling happened, why your spouse yelled at you, what your spouse was trying to do by yelling at you or insulting you, and how it made you in turn behave and react. Instead of saying, my spouse made me show receipts, you will probably want to explain that the mere fact that your spouse constantly pressured you and forced you and raised their voice to make you show receipts for all your purchases made you feel so scared and intimidated that you eventually stopped buying things or asking for money for items that you needed for your own survival. Or maybe instead of saying that they threatened to cancel your papers, you will want to now explain why the act of being threatened to have your case canceled put fear into you and made you give in to the demands that they were putting up on you and how it affected your daily life and your actions thereafter. And you will also want to explain why they would make such a threat in the first place, which would be to control you. Individually, these things might not sound dramatic, but of course, when you actually explain the intention of your spouse, the effect it had on you, where they were intending to control and dominate you, and where they succeeded especially, this is what's going to help you win your VAWA case. And this is what USCIS officers are trained to look for. People also worry about the following things hurting their case: staying with the abusive spouse, going back to their abusive spouse, never calling the police, or minimizing what happened to them. These things do not hurt credibility. However, you should try to explain these things through your affidavit. For example, if you did not call the police, what caused you from doing that? If you stayed with your spouse or went back to them, why? Details explaining these things will help give context to your story and will also help make it more credible and explain evidence that you have. Even though you are not required to explain why certain documentation may be missing, it always helps to give context and detail and credibility to your case if you do explain these things through your affidavit. Strong affidavits usually follow a simple flow. A strong affidavit will explain how the relationship evolved, how it started, and how it became serious, and give context to how abuse started, because the truth is that abuse doesn't come out of nowhere. Instead, there are a series of controlling actions and behaviors that your spouse may display that you don't always understand until later, because hindsight is 20/20. If you skip these things entirely and just jump right into the abuse, it may not be found to be credible for the officer. Make sure your affidavit is written in a clear manner and is not jumping all over the place or missing key context that makes it difficult to understand, because the officer is looking at hundreds of affidavits every day, and it is not their job to try to figure out what happened. Rather, you must present everything in a clear manner. If they're confused, they will either deny your case or issue a request for evidence. You also want to make sure that your affidavit is consistent with the details that you provide through your information on the forms, as well as through the evidence that you attach to your affidavit. And of course, if you have prior immigration filings with USCIS, such as a prior I-485 and I-130 filed by your spouse, you also need to make sure that the information given in your VAWA application is consistent with this information from before, or you will need to explain upfront why it may be inconsistent. Now, in just a moment, I'm going to explain two important things that may occur underneath this administration in your VAWA case: passing your interview and protecting yourself against ICE. But first, I want you to know that I am helping lots of people across the US, and I am accepting new clients. My name is Moumita Rahman, and I've been practicing immigration law for the past 15 years. If you would like my help on your VAWA case, you can give our office a call at 212-248-7907. We are based in New York, and we serve clients across the US. Now, I want to describe what is new underneath this administration for VAWA cases. The first are VAWA interviews. I want to clear this up because this is not happening at the moment. In fact, if you get called in for an interview, it is likely to be just for your I-485, and for an I-485 interview, your officer is actually not allowed to ask you about the abuse, because this is underneath the exclusive jurisdiction of the service center deciding your application for the VAWA I-360. Once your I-360 is approved, it means that USCIS has already accepted that your marriage was real, that you suffered extreme cruelty or battery, that you had shared residence, and that you have a qualifying marriage as well as good moral character. But if you have also applied for an I-485 adjustment of status application and you're requesting a green card, you will also be interviewed according to the requirements of the I-485, which has to do with inadmissibilities. So here is where you may have to talk about your entries and exits, criminal history, and whether you actually qualify for permanent resident. These are not the same as what is required to prove VAWA. However, that being said, there has certainly been a shift, and this year we are seeing more interviews for your I-485 than before, when many interviews were being waived. And if you get called in for an interview and you do not have an attorney representing you, the officer may take advantage of the fact that you do not have legal representation and ask you questions beyond what they are authorized to ask. And that's why I always tell people, never go to a USCIS interview by yourself. And in our office, we always accompany our clients to their interviews. Now let's talk about the other thing that I hear people talk about, which is fear of ICE. I want to be honest with you right now. ICE is certainly targeting more people. This includes people who are undocumented, who are overstays, people with pending cases, and especially people with removal orders. So in a time when even US citizens are being stopped and detained, there is not really a lot of filings that will help protect you. But one thing is certain, having a pending application in place can certainly help persuade an ICE officer to not arrest or detain you at all, or it can help you secure release quicker. Moreover, having an approved I-360 VAWA application grants you deferred action, which means that you are protected against deportation. So even if you have certain criminal convictions or an order of removal, once your VAWA application is approved, even though ICE may arrest and detain you, what it means is that they cannot actually deport you to your home country when you have deferred action. Of course, I'm not saying that ICE is following the law all the time right now. However, these are your legal rights. So you have certain protections that will exist simply because you filed your VAWA application. And something is better than nothing these days. So if you're going to apply, the time is now. The longer you wait, the greater the risk. Finally, if you want to understand what happens after you file, how long each stage of your VAWA case is actually going to take, when you can expect work authorizations, interviews, and other approvals, then you need to watch my other video, The Real Timeline for Your VAWA Case. In it, I break down every stage of the VAWA case based upon my experience filing thousands of these applications. I'll include a link to that video here. Click now and I'll see you there.